Yeah.
Right at the end
Wow.
of the day, but
Yeah.
then catch it at a I guess maybe we can go ahead and get started. Yeah, I guess we can go ahead and get started. So unless.
Well, that one guy,
Oh, I
I
thought
think,
he
stepped
stepped
out to get a drink. Yeah.
Oh, okay. Hmm? Yeah, I know. Be right there. I know. It's like there's some high quality camera work, by the way. Oh well, yeah, it popped in, popped out.
All right, now I think we can.
Now we're good. I know. I see it. Oh no, I just think it's funny. It's like I'm in the right position. Hopefully people can hear me. All right. So, good morning. I'm sure as people are coming in, people are going to learn more. But yes, my name is Reggie Parson. I'm the Deputy Director for the Maine Family and Medical Leave Program. And with me is Luke Monahan, who's the Director of the program, and Tim Applegate, who's the Director of Finance for PFML, and he oversees the portal, which I'll briefly talk about later. But just go ahead and get started with just a general overview and kind of how we got to this point. So in July of 2023, Governor Mills and the state legislature enacted paid family and medical leave, which made Maine the 13th state in the country to adopt its own state-run paid leave program. The law will provide up to 12 weeks of paid leave for the reasons that you see here, so either for family leave, medical leave, safe leave, or any leave related to a family member's upcoming military deployment. And one thing about this law in particular is that it is very broad reaching, meaning that it applies to many employers and employees in the state of Maine, with the exception of the federal government. That was an explicit carve out in the statute, but there are also 4 other groups in our rule that are exempted from eligibility, and those are students who are receiving work study money, any individuals who are working for the railroad industry, volunteers that are earning nominal wages, and the last one I think I named them all, including the federal government.
Did you say incarcerated?
Yes, no, that's right. Yeah, incarcerated individuals who are also earning wages. Right. So the reasons for leave. So as I said before, these are the general reasons you can take leave. So for example, if it's for family leave, it's either for individuals who are expanding their families through birth, adoption, or fostering, or to care for a family member who might have a serious medical condition. For medical leave, it's the employee taking time off for their own medical needs if they have them. And for safe leave, this helps individuals, employees, and their family members that may be experiencing some form of, domestic violence or abuse, and they may need to take time off to deal with that situation. And then finally, for military deployment, so one example is, someone may have a spouse who's an active duty member, and that other spouse knows that they're about to possibly be deployed. So obviously that's a huge transition that's going to happen, and so individuals can take time off to handle that other spouse getting ready to get deployed. So there's a cost to the program, and I'm sure many people are starting to feel the 0.5% deduction, at least for employees, being taken out currently. But I'll just talk overall about the premiums. So for the next 3 years, the premiums are capped at 1% of an individual's wage rate. There are two groups of individuals that can elect coverage, and those are either tribal governments or self-employed individuals. And if they do elect to be covered, they'll be paying 50% of that premium rate, or 0.5%. But we want to kind of give examples of what 1% is, because it might be different depending on the size of the employer. So for example, if you are an employer that have 15 or more employees, it's going to be 1%. And half of that can be deducted from the employee's pay, so 0.5%. So we just used a general example here. Someone, employer who has about $1 million a year payroll, that annual premium for that business will be about $10,000. And so the employer will be contributing $5,000 of that, and the employees will also be contributing $5,000, so equaling 1%. If you are an employer with less than 15 employees, that premium rate is going to be different for you. So for businesses of this size, it's going to be 0.5%. And so that can come either from an employee's paycheck, or the employee can voluntarily choose to pay for it. And that also applies for businesses with 15 or more. The reason why there's a difference in a breakdown depending on the employer size is by law. So the legislature enacted this kind of premium breakdown depending on the size of the employer. So to kind of put this more into context, these are just 3 general salary examples that we used, because people might be going, okay, what is 0.5%? And obviously, you know, this will be dependent on the actual premium amount. How much comes out will be dependent on how much you actually earn. But these 3 general examples kind of lay out 3 different income scales. So someone who's earning about $35,000 a year will be paying no more than $3 a week for paid family and medical leave. If you're earning about $57,000, it could be around $5.48. And if you're in that higher income scale, about $90,000 is going to be about $8.65 a week, only looking at that 0.5% deduction. So obviously people are paying premiums into it, but there's also eligibility that has to be met as well. So so I would say for this, when it comes to eligibility, the benefits won't go live until 2026. But right now, people are paying the 0.5% to basically fund to build the trust fund, so we can pay benefits. So when it comes to an employee applying for the program, they must give their employer notice for leave that's not an emergency. So when we say reasonable notice, we said in the rule 30 days would be sufficient notice, or should be sufficient notice. But there's one bullet point at the bottom that gets to undue hardship, and I'll talk about that later in connection to giving notice. But again, generally employees must give notice. Proof must also be provided, and again, once we get to we're already thinking about the benefits part now. So once that really kind of gets in effect and going, the employee will likely have to provide some type of proof that they need the leave. So for example, it's for a medical condition, either for themselves or a family member, they might need to go get a certification from their doctor, kind of confirming that. But once we get to the benefit side of it in 2026, and we're probably going to do another public education campaign, hopefully things will become a little bit more clear. There's an income requirement attached to this too, so people must earn or be working or earning some type of income in order to be eligible for the program. So you must earn at least 6 times the state average weekly wage in order to access the benefit. The state average weekly wage is a number that is announced on an annual basis by the Maine Department of Labor. And so every July 1, the state average weekly wage changes. So what I'm using here is based on 2024. Probably sometime around July 1st of 2025, that state average weekly wage might change, might be different. But they take into account in determining what is that state average weekly wage by wage data from both the private and public sector. So this is something that is really the 30,000 foot level, and they come up with this number. So for paid family and medical leave, this is how we'll base how much, whether you've met the monetary requirement. So for 2024, it'll be $6,864, and that'll be over the course of the year that you have to earn that. So yeah, so it's not like you have to earn it every single quarter. We'll look at really the totality of it all.
That's 1144 times 6. So 6 months would be the 6,000 double, or is it 6,000 for the 12 months?
Yeah, for the whole 12 months. Yeah, so it's like a math formula. So if you apply the state average weekly wage, which is right now $1,144 times 6, yeah, that's the cumulative amount that they have to earn. So 68.64. So yeah, and then finally, when it comes to undue hardship, this is why I kind of saved that one for last. So in the statute, an employer can claim an undue hardship if that employee's, proposed leave schedule may cause some type of disruption in the operations of the business, and this is going to be one of the more complicated things, to be transparent, that I think is going to be new for paid family and medical leave. I know it's in another, in the earned paid leave law when it comes to undue hardship, but for our law, again, I think there's going to be some education between both the employee and the employer about what undue hardship is. But we do have built in our rule that in many cases it might not cause an undue hardship. And if that is the case, the employee comes to the employer with the leave schedule, the employer has no issues with it, they can sign a waiver. And that really will expedite the claim process. But if there is an undue hardship, that's where things kind of slow down a little bit, and the state has to assess whether that does cause an undue hardship. And if it does, it could potentially change the employee's proposed leave schedule, so they might not be able to take the leave in the time that they're asking for. It might be some changes in that. But it won't mean a denial of paid leave. It's just when they take their leave might change. So in terms of the benefits, and this is where, when we do a public education campaign next year, we hope to kind of simplify this more. But the benefits are going to be based on a two-tiered wage system, and I have a chart that kind of makes this a little bit more easier to understand. But generally, individuals, and we'll look at their wage data when we're doing this. So if an individual has earned at or less than 50% of the state average weekly wage, so again, it's that number that you saw before of $1,144, you essentially slash that number in half, and that's 50% of the state average weekly wage. An individual's weekly benefit amount will be replaced at 90% under that tier 1. For any earnings over 50% of the state average weekly wage, we also have to replace that as well, but only at 66%. I think the chart here the next chart I'll show will make that hopefully a little bit more clear. But the benefits are capped, again, at the state average weekly wage. So someone, especially probably who may be earning a little bit more on the high income scale, probably around that $90,000 to $100,000 range, they will likely hit that weekly benefit amount cap. For 2026, I obviously I can't speculate what that state average weekly wage will be, but either way, the benefits are going to be capped. And then finally, benefits will go live in May of 2026. Right, yeah, it's going to be capped at the state average weekly wage. Yeah, so that's why at that bottom, the bottom column that you see here, I put a little asterisk. Someone who's earning about $90,000 after we do the calculations, in theory might be earning more than that, but again, by law, we have to cap it. So this chart will hopefully kind of make things a little bit more self-explanatory. So I'll just start with the $35,000. So if someone's earning that wage per year, divide that by 52 weeks, they're going to be earning about $673 a week. So in order for us to figure out the whole weekly benefit amount, we have to start again at that tier 1 wage replacement, which is at 90%. So any earnings at, as I said before, any earnings at or less than 50% will be that number, that next number that you see here of $514. Pretty much probably everybody is going to be receiving that amount equally, because again, we have to apply it to earnings over 50, or apply it to 50% of whatever the state average weekly wage is. But because they earn more than 50%, so they earn about $673 a week, we also have to replace that tier 2 at 66%. So when you really combine tier 1 and tier 2 wage replacement, the last column is their weekly benefit amount. And not everybody will take 12 weeks. Some of these individuals may take 4 or 6. It'll all really be dependent on what their needs are for paid family and medical leave. And then again, you'll see what someone who's earning about $57,000, how we're going to go through that tier 1, tier 2, and that weekly benefit amount. And then again, finally, someone who's earning probably about $90,000 is going to be capped at the state average weekly wage. So some other things to kind of keep in mind about this program does have job protections, meaning that if the employee is eligible to take leave, depending on how long they've worked with that employer, they may be eligible or entitled to return back to that job. So if you do have an employee who's worked for you for at least 120 consecutive days, they are entitled, the employee, to return back to that job, including the benefits that they had and basically all the things that they had before they took the leave, or something equivalent to that. So, but for employees that have not worked for you for at least that 120-day mark, they're not entitled to return back to that job. So they may be able to take the leave, but the employer doesn't have to guarantee that they'll have that job for them when they come back. And that's where, again, once we do more education around the benefits as we get to 2026, we hope to kind of flesh that out a little bit more. The benefits for this program are portable, meaning that it's not tied to an individual's job. So we know that people have worked more than one job or kind of leave jobs throughout the year. So just because they maybe leave you as an employer, doesn't mean that they will never ever be eligible for paid family and medical leave. And so I think that was the intent of the law, is to make sure that there was still some flexibility with that. Yeah.
So let's say that the person takes a leave and they hop back to work, let's say it was more than 120 days,
Mm-hmm.
and about 3 months passed and something happened,
Mm-hmm.
people need to leave again.
Mm-hmm.
Is that
Yeah, that's a good question. Yeah, so again, individuals can take up to 12 weeks in a benefit year, which I think is on a rolling calendar basis. Yeah, so an employee might, use 6 of those 12 weeks, and then, like you said, something happens later, and they might need to take another 2 weeks. So individuals, I didn't put this in the slides, but there are 3 types of leave that individuals can use. So that person might be intermittent leave, which will count towards the 12 weeks, or they might just take straight, I'm taking 6 weeks off. So there is flexibility, but they cannot use no more than 12 weeks in a benefit year.
for the year after it comes back with the same time amount?
Yeah, there's no lifetime cap. Yeah, so it expires and it kind of rolls back again. But that's a good question though, because life happens, and so people might need.
So it's a rolling calendar, you said?
Mm-hmm.
So your leave actually, the year starts the day you start your leave.
Mm-hmm.
So it's 12 months from that first day.
Yeah. Yeah.
So you use that 12 weeks of leave for the same condition.
Potentially.
Separate it up into, like, if you had to take a month off, but then 3 months down the road, oh my God, the condition came back.
Sounds like intermittent leave. Yeah, you can use intermittent leave for that. Yeah, but again, and I think that's where it gets a little technical, because I think if it's for intermittent leave, I don't think do you have to go back?
I mean, you could have like a
Yeah.
continuous of a month, like you saying,
Yeah.
and you have another event or a flare-up
Yeah.
of a condition,
Yeah.
you need to use another month,
Yeah.
you could have separate claims of continuously.
Right.
You have
Right.
to have, you have to get it approved every time it's the same condition.
So that's where the intermittent.
Right,
comes
yeah,
in.
that's
so
where
if
it
you
gets
have
technical.
let's say you have a chronic condition and you know that you have the potential to have a flare-up, throughout the year, like rheumatoid arthritis is a good one. Like you can't predict when you might have a flare, but every time you do, you're going to be out of work probably for a week or two while you're getting better. So you can have a blanket intermittent approval for the year if your doctor writes a note saying, may have up to 4 flares per year, a week per flare. That creates an intermittent claim where you only have to have that approved once, and
Yeah,
then
that's
when
what
you
we want.
have a flare, you just report to your employer and us that you're using time under your intermittent claim.
Would that also work as if you're taking leave for a family member who may have flare-ups through the year?
Same concept. Yep.
Yep. Yeah. No, these are good questions. Yeah, and again, as we get into 2026, so right now we're in the process of trying to find a third-party administrator to do basically the claims administration for this. So once we figure that out, we're, going to likely do another public education campaign to kind of help people talk about, okay, what can I use it for? Do I have to keep going back to submit, multiple, doctor's notes if you need to? Okay. All right. So I don't know how many employers are in the room. I'm assuming there might be many. So the Maine paid leave portal is a new portal to the state of Maine, and we've gotten a lot of questions around, why could there not have been an opportunity to use an existing portal like the unemployment portal that many employers are probably familiar with. That is something that we worked through intensely to try to see if we could use existing resources, but ultimately it just wasn't feasible. So we ended up using going through a competitive bid process to find a vendor to help us develop this portal. And so this is the portal that you now see publicly. But this is more of an employer-facing portal where the employer will have to register the business. They will have to report how many employees they have. So again, whether you did have 15 or more employees. And this is where also on a quarterly basis, you'll be remitting the premiums and then filing the wage reports on a quarterly basis. I believe we tried to time it up almost similar to unemployment in terms of when the due dates are.
Yeah.
Just for administrative ease, knowing that employers might have to report to UI, and now you can also report to the portal, and just kind of knock everything out, at one time. The portal did launch on January 6th. We did do a soft launch a week before just to make sure that the system was ready to go, but we did a full launch on January 6th, and so far we have been receiving some positive feedback from employers. The average time to register was about 12 minutes, and so it hasn't been anything that has, caused someone to spend their entire day or half a day to do. And Tim over there in the corner is more than happy to answer any questions, definitely about more of the technical aspects of it all. But this is also where, again, self-employed individuals and tribal governments can elect coverage, so you can do it through the portal. And then we'll also be using the private, if you want to apply for a private plan, which won't open until April 1st, you'll be able to go through the Maine Paid Leave portal to do that as well. The wage reports, again, for the first quarter of 2025 won't be due no earlier than April 1st and no later than April 30th. So again, we're trying to, for administrative ease for the employer and familiarity, trying to time it up for potentially when UI is due for unemployment insurance. So finally, these are some things that you can do, and we definitely encourage you to do one and two for sure, because on our webpage, we update that webpage as much as we can. On the website, you'll find up-to-date FAQs, explainer videos that are translated in multiple languages too, and so is our FAQs. And then also too, on our website, I would encourage folks, if you haven't done it already, to sign up to be on the interested parties list, because we use that as a channel constantly to tell both employees and employers any updates about paid leave or any action items that they may need to take care of. And as I said before, we have a ton of information that's available. And for employers, the portal is still open. So, if you can register as soon as possible, that'd be great. So you can just kind of, have a little bit of peace of mind before first quarter filing. And we do have a call center. So if you do have general questions about paid family and medical leave, you can call 621-5024. The hours are available from 8 a.m. to 5 Monday through Friday. And with that, are there any questions? No, this is good.
My grandson is a farm worker from the state of Maine, and I work with a lot of farmers, and I get so many questions on that subject. So we do HOAs a lot, and those are temporary timeline. Usually stay 2, 3 to 6 months in the state, and they kind of read it all, the questions, and they technically qualify, but they don't see the benefit for them. So are they obligated to pay more?
Yeah, so we've gotten this question a lot. So H-2A workers would be paying premiums into the program, and we also got the second question tied to that, the eligibility piece. So it's really hard to, I guess, also right now, especially to determine whether someone is going to be eligible for the program, because again, it's going to be based on the wage data that we have on file for the employee. Did they give the proper notice on all of those things? So it's really hard for us to, I guess, to say now in 2025 whether they're going to be eligible, but the law itself did not exempt H-2A workers from paying into the program. And I see Jenny back there. Yeah. Yes.
Specific to H-2A workers
Mhm.
here temporarily.
Right.
One of the key parts of eligibility
Mhm.
and being able to partake in your investment in paid family medical leave
Mhm.
is having access to medical authority who can sign paperwork for you.
Right.
I think that needs to be looked at.
Yeah.
If you don't have access readily available to medical care providers, that means that you don't necessarily have equitable access to partake in this program,
Right.
which you are being required to contribute.
Right. Yeah. No, that's a good flag, because obviously we want people to have access, but if if it's for a medical condition, we don't want a barrier to be in the way of that. So that's a good catch.
Specifically that HOA got in a car accident,
Mm-hmm.
and yes, the liability covered all the medical,
Yep.
but he needed to be another 6 extra weeks before he could get back, and it was capped. So the farmer was taking care of it for the out of pocket. So in that
Okay.
situation, if he had the medical, would he be covered?
Yeah, if he met the wage threshold.
Yeah.
So if he had, worked enough to hit that 6,800, and they had medical documentation showing that he's unable to work for a period, that would meet eligibility criteria, and they would have the benefit to cover that.
Because that would be one benefit to
Yeah.
justify the cost.
Right.
Because the farmers is like, okay, what's the benefit? They can't use it. We
Yeah.
have to take it from them.
Right.
They're not going to be happy.
I know. Yeah.
The other, I think, example, if you hit, again, you have to hit that wage threshold, but once you do, you're eligible for the program, is they're also eligible for the intermittent claim. So if they're managing a chronic illness, and I know that access to medical care is a barrier, and that's true of, a lot of populations, but if they do have medical care and they have a chronic condition, they can still work, but they just might need some added time off to get to appointments.
The thing is that they cannot exceed the timeline when they're here, and it's usually no more than, some of them is 8 months.
Yeah.
But they are limited to the visa process, so it's very weird to say that they have to pay for something that they can't actually use it.
Right. Yeah. And so.
Extremely cases.
Yeah, and that might be something, when the legislature wrote this, obviously, and I don't know what their intent was about the H-2A workers, but I think that might be something, because our role as a department is to try to implement, the will of the legislature. But if there are things, and we actually have Jenny Tilton-Flood, who's a member of the Paid Family Medical Leave Benefits Authority, who's a great advocate for, making sure that, yeah. But if there's anything regarding legislative changes, they would definitely need to.
Yeah, I
Be by the legislature.
They have to, because they asked me that question often.
Yeah.
Yeah.
Sure. I would kind of know.
And Jenny
Yeah.
did ask this question, and we did some research just to,
Right.
to educate ourselves about other state paid family medical leaves, and every state we can find does cover visa. It's coverage regardless of visa status, and
Yeah.
there are people who are using the program in these other
Yeah.
states.
Yeah.
Um,
Use it, it's fair.
Yeah. So I mean, it's definitely, it seems to be the norm. We are the 13th state so far, and there's no state that excludes workers that we can find based on visa status.
Yeah.
So, what if you work for an employer that offers short-term disability and you are on short-term disability through the company, but your short-term disability runs out and you are not able to come back to work? Can you just change over to family medical leave, or?
Yeah, so if you are using short-term disability benefits and paid family medical leave, we won't reduce your benefit amount if you're using that, just so long as it's not exceeding what you typically make at work. And so I don't know enough about short-term disability benefits to say, what happens after that expires. But if you, depending on the amount of weeks that you need for leave, that won't make you not eligible. It'll just, maybe your STD benefit won't be available, but your weekly benefit amount will still be
Well, I can
available.
speak to that a little bit.
Yeah.
Yeah. So I think employers are going to probably evaluate what they have, currently, if they want to switch to a private plan, if they want to stay in the public plan, because that short-term disability policy is not going to be a sufficient private plan for an exemption because it covers only medical claims. It doesn't, offer parental leave, for instance. But let's say an employer stays in the public plan and also keeps short-term disability. What would happen, I think, is you would probably take the PFML claim first, and you could use it's all going to depend on the structuring of the policies of the short-term disability. If they allow the augmentation of wages, because like Reggie was showing in that chart, you might only have 50% wage replacement, but a short-term disability policy, if you're taking a claim from that as well, could bring you back up to your 100% wage replacement. But if you're out on short-term disability first, generally what an employer will do, if it's subject to federal medical leave, unpaid leave, is they'll run your absence with unpaid federal leave, and that does reduce your available time under PFML. And so if you were under an employer who had short-term disability and you took only short-term disability if you had a medical event, and they were running out your FMLA time on that, and let's say you use a full 12 weeks, you would not be eligible to take more time under PFML because you've used your bank of, FMLA, which we run concurrent with our program.
But what if you're not using the FMLA for while you're on short-term disability? If you're only touching the short-term disability through the company, and you're not applying for the family medical leave, but then your 12 weeks runs out for your short-term disability, but you can't come back to work yet because of a medical condition. And then after that expires, go right into 12 weeks of paid family medical leave.
I think it's going to depend on how the employers structure it, because the employer has the right to designate time off as FMLA. So even if you, as a worker, took a short-term disability claim, and you're like, I don't want to use FMLA, the employer can run that time off as FMLA. But I think they would actually be more so in reverse, that an employer would say, you should apply for PFML first, and then we'll offer this short-term disability policy after, because short-term disability policies usually cover up to 6 months or up to a year. So I think they would probably offer that at the back end of PFML, that, PFML is like a very short-term disability policy that also has, family leave and parental leave, but it's only for that 12 weeks. So where if you have a condition that really brings you to that year of a short-term disability policy, I think they'd have you apply for short-term disability if they offer it at the back end of a PFML claim. But I think that's going to be, how employer structures their policies. And then once you hit a year, it's, whether or not you have long-term disability at that point.
I'm not an employer, I'm an employee. So
Yeah.
I'm on the other line.
No, it's a great question. The interactions of benefits are really going to change, I think, based on this new law.
That would apply to, say, if you had,
Yep.
that offered you a discounted rate at an insurance company, like Global Life, you would have to take that separate and at another time than this one. You couldn't run it.
It depends how the employer or the union offers it.
Say this is in Maine, and you guys got very close to
We have income protection, which I think is short-term disability.
We got income, income protection.
Yeah.
Is what I have.
Yeah.
And I could take it, but I couldn't use it the same time I was taking workers' comp.
Yeah.
But I could use my own time
Yeah.
and get paid and take income protection on the same time.
Yeah.
So I can get paid for income protection for X amount.
Yeah. Yeah, the way it's structured in the rules is you can bring yourself either with your own time if the employer allows it up to 100%, or if you're taking a short-term, you can use some time if the employer allows it, some time to bring you to 100%.
You know if the state's gonna allow it for state workers?
They haven't made that decision yet. You know, we're not making the decisions for the state, but we're actually waiting on that decision from them. So a short-term disability plan can bring you up to 100%, and your own PTO, your paid time off that you might have accrued, can bring you to 100% if the employer allows it. But the intention is not to go over that 100% with either your own time or short-term disability. Right, you don't want to,
Yeah. Happy to take any other questions.
So if I employ on a farm a number of people and they're not going to reach the benefit threshold, we still pay in, they still pay in, we still pay in.
Yeah, the way the law is structured, they do, and I mean, for many reasons, I think, but I think partially they could have multiple jobs, you know, so an employer, you don't know if they're going to hit the wage threshold, or you know they may not hit the wage threshold with you, but then they have a second job, and we pool together the income when we're looking at the eligibility, and it's over the course of, you know, like Reggie said, a year. So you might work on a farm, you know, over the summer or over the harvest season, and then you go and you work in the hospitality industry in the winter, and when you pool those jobs, you do actually meet the wage threshold, you know, going forward. But the way the law is structured, yes, it's regardless the amount of income you have, you would pay the premiums. But when you apply for a benefit, that's when the wage threshold is applied.
Yeah.
So as an employer, I pay in when I have 50 employees?
Yeah, if you have 15 or more, you would have basically a 0.5% match. Yeah.
I have one more question.
Yeah.
Oh, ask away. No, that's why we're here.
I used to be a chief steward for a union for 12 years, I'm not anymore, but. So, in a case where you have a medical condition where you have a doctor saying that you cannot work, but then the company says, well, I can't approve it because it's undue, would you say?
Undue hardship.
Hardship for them, how do you manage that?
Yeah.
So that's actually
Yeah.
a very good
Good
question.
question, yeah.
If it's a medical claim only, so if you're taking leave for yourself due to your medical condition, and you have a doctor's note saying, you know, I'm unable to work for this 4-week period, and your employer says that's not going to work for me. That time frame's our busy time, and you guys, you know, the employer and the employee can't come to an agreement. The way the rules are structured now is that for medical claims, it would go back to the medical provider because like Rosie was saying, undue hardship, you can't deny it. You just need to see if there's a schedule that works better for the employer that's not an undue hardship. But if you can't agree, the two parties, then it would go back to the medical provider, be like, okay, can it be delayed, you know, with the employer's schedule? And if the medical provider says no, you know, that would cause medical harm. Ultimately, it would be the employee would get leave. Yep. That's only for medical claims, not for, yep.
Right.
Well, we're gonna see a lot of that, especially in the corrections, where they're down so many people, and a lot of people get injured or have children or
Right.
attacked. They don't have a lot of staff right there as it is.
Yeah.
And if they happen to all take it off in the summer, which sometimes they're all sick in the summer.
Mm-hmm.
But it's gonna create.
Although corrections are usually unionized too.
We are.
Yeah.
Yeah.
Last week.
Yeah. Are you a correctional officer?
Yeah.
Oh, we'll have to talk after.
Yeah.
Yeah.
Yeah. No, they
I used to
yeah,
work in
yeah, you used to
corrections,
work
yeah.
in DOC.
You in Monahan?
Yeah.
Yeah.
CC?
Yeah.
Yeah, yeah.
We'll
See,
catch
we-
up.
Yeah. Yeah. See, we bring people together. Yeah.
I was a caseworker before that. Yeah.
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 Does it make a difference if there's a union involved in any of this?
So,
it
yeah, go ahead.
does-
You can take
Yeah,
that.
it does when it comes to collective bargaining agreements for the public sector. So, and we've clarified this thing to death, and hopefully we clarified it enough up to this point. But the way that the law has been read or clarified is that if you had a collective bargaining agreement in place on October 25th, 2023, the public sector employer and its employees are not required to participate until and participate in PFML until that first date of the contract expiring. So, yeah, and
That doesn't affect us. We're private.
oh, okay, yeah. So yeah, for private sector it doesn't, but for public sector, yeah. Yeah, yeah. So and we've gotten a lot of questions from school districts and municipalities and counties, like, are we in
Military as well, right?
for federal or the guards, state National Guard?
National.
Ooh, I don't think we.
Because federal military, if they're
Because I don't think that they are, because my husband's in the military. So
Yeah.
I don't think, I asked yesterday, and he was like, I don't think we are paying anything, or they didn't even hear anything.
We've been trying to do outreach with the guard, and they haven't gotten back to us yet. But that's thank you for reminding me, because we might have to poke a little bit more to.
He has no clue, and he was.
Okay, yeah.
Yeah, but any of the federal arms, like Army, Navy, I would imagine they're federal workers,
Yeah.
quote unquote. Yeah.
Yeah,
So
they're
they would be
federal, right.
exempted by the law.
Yeah.
That's what he said to me. They are exempt. I was like, I don't think so. But
Mm.
sure.
There is an exemption for federal employees.
Yeah.
Yeah.
Yeah, he's on the. Yeah, I guess.
Yeah, but no, we probably need to poke the guard again to just let them know, like, paid family medical leave may be available in terms of like military deployment and how that will apply. But yeah, we might have to.
Yeah, that's why I thought it was
Yeah.
related. Cause
Yeah.
it's related. Maybe one of the classifications. For
Right.
military company.
Right. Okay. But yeah, kind of going back to the public sector, yeah. So, but we did clarify in the FAQ that if both the union and the the union and the employer wanted to participate in paid family medical leave, they could. They just have to go through the bargaining process, but you're not required to do that. So when the first date of that contract expires, then you're in paid family medical leave. So if you had a contract in place and nobody wants to reopen it, then it won't.
So that would be
yeah.
available next year, right?
Yeah, for benefits, yeah, in 2026. Yep. Yeah, so contracts will be expiring, and if once it does expire, then the employer will then have to report into the portal and then submit the wage reports and pay the premiums. That's a good question, though.
We are a state. I don't think we are paying this year. I think the state is paying for us, right?
Until October.
The state came out, I think it was a month ago at this point, with the decision, I guess, up until October, that state employees, and I don't know if that applies to the legislature or the judicial branch.
I
but
don't know
yeah,
that,
right.
yeah.
So, but DAFs, they said that the 0.5% deduction won't come out of our pay up until at least October of this year. So, yeah, but that was the state's decision.
The lawsuits that's been filed, is that gonna somehow affect the implementation of any of this stuff, or is it?
Yeah, unfortunately, we can't comment on the litigation right now, but it's something that we're constantly monitoring. But I think.
But in terms of the rules, like
in terms of the rules,
the rules
yeah,
of the law are in
yeah.
place, and so everything's status quo right now. That
To the court.
everything that's in place is going forward. So.
Yeah.
I'd like to follow up, because this is a question I had as a member of the authority. Is there a possibility of an injunction being enforced with regards to the implementation in 2026? If
Yeah.
perhaps, say, the legal road is a long one, which I sometimes do.
There has not been an injunction filed. Yeah.
Yeah.
I just also have another comment. If folks have not yet called the helpline or
Yeah.
reviewed the FAQs, really, really highly recommend. You can get really good answers from them. Ask people about being able to talk to people, whether through a translation service or whether they'll have first-person speakers of other languages. It's been very helpful as an employer. It's been helpful for me on behalf of my employees and my team as well. So highly recommend.
I've been recommending the farmers the line, because since I did not have enough information, I could pass through it when I was referring to it.
Yeah.
And the line does have translation ability too.
Yeah.
If you have
I did not know that.
Yeah.
The farmers are the ones taking care of it anyway. So
yeah.
it's good to know as we move forward in implementation.
Really important for people
Yeah,
to
because
have
I do
Yeah.
I do field presentations with the workers constantly at farms, and a lot of them Spanish speakers, or speaking like French Creole and
Yeah. Yeah, we actually, again, have explainer videos that we just put it online that are translated, I think, in Arabic, French, Spanish, Portuguese, Haitian, and Somali. So and English, so 8 languages. Oh, yeah,
Yep.
yeah,
Okay.
yeah.
Because I do bring in all the information to the field, so it's
Okay.
Yeah, the explainer videos, like Reggie said, are FAQs, and then our general, not this presentation, but a similar one is translated in those 7 languages.
Yeah, and our posters.
And the posters, yeah.
Yeah, by law we had to translate them. I think in Spanish, French, Portuguese. There was 4 languages, so if you need those translated labor posters, they're online too. Yep. Yeah.
That's such a thing.
Yeah. Yeah. Any other questions? I have my card here. If something pops up, as you're thinking about it more, I'm happy to, reach out. Well, you can reach out to me by phone, but I'm definitely by email ready.
The first meeting that you guys did today,
Yeah.
everybody was, the next day was the hotline. Everybody was, what is that about?
Yeah.
Like, get more information.
Yeah. We're doing a public education campaign now, and it's launched in October. But I think people are more and more starting to wake up to the fact that we do have paid family and medical leave here. Because a lot happened between the time the law passed and then we did that first kind of public education campaign. We have that, and so I think now people are,
At first,
reaching out.
I just heard like I had to pay.
Yeah, I know. That's why we warned you. So that's exactly why we did the public education campaign, because we didn't want people come July to go, what is this 0.5% and what is this for? Because we didn't want people to, be protesting us in front of the Department of Labor.
Started this month.
Yeah, it started already. Yeah, so people are starting to feel the effects of paid leave, but it's gonna. And I know some people are like, why am I paying to a benefit that I can't utilize yet? But the way that the law was structured, the trust fund needs to be built up in order to pay the benefits. So,
No, I understand.
yeah.
There's a lot of people that don't get it.
Right. Yeah,
And
but
a lot of
keeps
people
it.
somehow totally forget that they're allowed to use it. They're like, well, I'm not having any kids in the future. I'm like,
It's more than that.
"Oh,
Yeah.
okay."
Yeah.
You can use that if you have to go to the hospital for surgery or.
Yeah.
You know,
Oh,
they don't get
everything
that.
happens.
Yeah.
Everything happens.
Yeah.
Life is unpredictable.
Yes. Yeah. Well, awesome. Well, we're here for a little bit longer. So if you have any other questions, come up and stop by. But thank you for coming. Yeah. Thank you.
Thanks.